Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw. We bring you the latest and in-depth legal coverage. Here is a brief of what all happened in the Indian courts today. Starting with an update on the plea filed by 26-week pregnant woman for medical termination of pregnancy. As you know, the matter was heard last week at length and breadth, and today the court finally delivered the judgment. The case had been filed on the ground that the petitioner, a married woman with 2 children, is suffering from postpartum psychosis and is not in a position to raise a 3rd child emotionally, financially, and physically. In the last hearing, the court had doubted the authenticity of her postpartum psychosis prescription. The bench had asked AIIMS to conduct an independent evaluation of the mental and physical condition of the petitioner and to examine if the medicines taken by her had any effect on the fetus. Today, the court was provided with the report of AIIMS, which affirmed that the petitioner had in fact been suffering from postpartum psychosis. As per the report, she was taking medications which were not affecting the child adversely, and it was also reported that no abnormality was detected in the fetus. The court today rejected her plea to abort the 3rd pregnancy. The order was passed by a bench comprising CJI D.Y. Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra. Noticing that the pregnancy had crossed 24 weeks, the court stated that permitting the petitioner to carry on with the termination of pregnancy would violate provisions of the Medical Termination of Pregnancy Act. The bench clarified that the cost of all medical procedure in the matter would be borne by the state and the petitioner would have the ultimate say on whether she wanted to keep the child upon being born or give it up for adoption. The court also refused to hear a challenge to the upper limit for medical termination of pregnancy as 24 weeks by means of an intervention in the proceedings. The court stated that the challenge to the existing law would be addressed through separate proceedings, while the ongoing petition shall remain a matter exclusively between the petitioner and the state. In an important update from the Allahabad High Court, it today acquitted the accused in the Nithari killings case. Surinder Kohli, the prime suspect, was awarded death penalty by the trial court in 12 cases. Now he has been acquitted in all 12. Another suspect, Maninder Singh Pandey, has also been acquitted by the court in 2 cases in which he was sentenced to death by the trial court. This is the case related to the infamous Nithari murders believed to have been committed between the year 2005 and 2006. The matter came to light in December 2006 when skeletons were found in a drain near a house in Nithari, Noida. Maninder Pandey is the owner of the house and Kohli was his domestic help, and hence both were implicated in the FIRs. The CBI registered a total of 16 cases. As per the CBI, Kohli had killed several girls by chopping off their bodies to pieces before throwing them in the backyard outside their house. After their conviction by the trial court, the duo approached the High Court. A bench of Justice Ashwini Kumar Mishra and Justice Syed Aftab Hussain Rizvi had reserved the judgment last month and today allowed their appeals. For the detailed judgment, please visit our website at livelaw.in. The Supreme Court bench comprising Justices Sanjeev Khanna and S.V.N. Bhatti today heard the bail applications of Aam Aadmi Party leader and former Delhi Deputy Chief Minister Manish Sisodia in the CBI and ED cases in connection with the alleged liquor policy scam. Additional Solicitor General S.V. Raju today continued to highlight the proximity between Manish Sisodia and Vijay Nair. He also said that changes proposed in the new excise policy were not a means of reforming the liquor market as suggested, but a way to ensure exorbitant profits for certain private companies. Significantly, the law officer told the court that ED was contemplating making the Aam Aadmi Party an accused in the money laundering case and invoking Section 70 of PMLA to probe the aspect of vicarious liability. Though senior advocate Dr. Abhishek Manu Singhvi, appearing for Sisodia, said that the statement was meant for media attention, Justice Khanna clarified that it would not in any way affect the decision regarding the bail of Sisodia. The hearing in the matter will continue tomorrow. Stay tuned with us. And now an update on the ongoing NewsClick case, or the UAPA case against NewsClick founder Praveer Purkayasth and Human Resources head Amit Chakrabarti over alleged Chinese funding to promote anti-national propaganda. As you know, last week the Delhi High Court had upheld their arrest by the Delhi police in the case, saying that there was no procedural infirmity or violation of any provision under UAPA or the Constitution. Now they have approached the Supreme Court against this order. The matter was today mentioned by senior advocate Kapil Sibal before the CJI for urgent listing, who said that he would take a call on the same. Congress leader Dr. Jaya Thakur has filed a plea in the Supreme Court seeking immediate implementation of the Women's Reservation Bill before the Parliamentary General Election of 2024. As you already know, last month the President signed into law the Women's Reservation Bill that had been unanimously passed by both houses of Parliament. It seeks to reserve 1/3 of seats for women in the Lok Sabha and the Delhi Legislative Assembly. The Act also introduces horizontal reservation for women from scheduled castes and scheduled tribes within the women's quota. However, as per the Act, women's reservation will come into effect after a delimitation exercise is conducted following the next census and will be in operation for a period of 15 years. The plea filed by the Congress leader seeks to declare this clause as void ab initio and seeks immediate implementation of the bill. The plea states that constitutional amendment must not be withheld for an uncertain period, especially because the bill was passed in a special session specifically called for this purpose and had been unanimously passed by both houses of the Parliament. The Supreme Court today referred the petitions challenging anonymous electoral bonds scheme to a constitution bench of 5 judges. The case involves a batch of petitions challenging the amendments introduced by the Finance Act of 2017, which paved way for the anonymous electoral bonds scheme. According to the scheme, a donor can buy an electoral bond at specified banks and branches using electronic modes of payment and after having completed the KYC requirements. The bonds can be bought for any value in multiples of ₹1,000, 10,000, 1 lakh, 10 lakh or 1 crore. Political parties are not required to disclose the source of these bonds to the Election Commission of India. The name of the donor will also not be there in the bond. The petitions challenge the scheme as an obscure funding system which is unchecked by any authority. Also, in March 2019, the Election Commission of India had filed an affidavit stating that anonymous electoral bond scheme was a retrograde step as it has serious impact on transparency in political funding. In another update, the Supreme Court has issued notice on a writ petition filed by Aam Aadmi Party leader Raghav Chadha, challenging his suspension from the Rajya Sabha during the monsoon session. During the session, Chadha had moved a motion to refer Delhi Services Bill to the Select Committee and named certain MPs as the proposed members of the committee. It was alleged that Chadha included the names of certain MPs in the motion without their consent, although they were from parties which were supporting the bill. Based on a complaint that Chadda's action violated Rule 72 of the Rajya Sabha rules, the Rajya Sabha chairman suspended him pending inquiry by the Committee of Privileges. In the writ petition filed against the Rajya Sabha Secretariat, the Aam Aadmi Party leader has challenged the infinite suspension as illegal and arbitrary and amounting to violation of rights of the people of Punjab who he represents in the Rajya Sabha. Senior advocate Rakesh Dwivedi, appearing for Chadha, argued that a select committee must be a multi-party committee and its members are appointed by the council itself. A member can only propose certain members and Chadda's motion was to that effect only. He claimed that in the past there were 11 incidents of motion for select committee being moved, citing the names of proposed members without ascertaining their willingness. If the members say that they are not willing, then their names are dropped and someone else is appointed. He contended no member had faced any action for proposing select committee members without their consent, and this was a selective targeting of a vocal member of the opposition. A bench comprising CJI Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra today issued notice to the Rajya Sabha Secretariat and posted the matter to 30th October. The Supreme Court has granted relief to a person with colour blindness by directing the Tamil Nadu Generation and Distribution Corporation Limited, that is TANGEDCO, to appoint him as an assistant engineer at an appropriate grade of pay. The case is regarding a job application for the position of assistant engineer by the appellant. He was initially considered qualified for the role. Subsequently, during a medical examination, he was found to be colour blind. This raised concerns about his ability to fulfill the responsibilities of an engineer, which frequently involves working with color-coded power cables and wires. As a result, his candidature was rejected. The appellant challenged the rejection before the High Court, which initially ruled in his favour, but on appeal, the division bench observed that TANGEDCO's decision had a reasonable basis. So he appealed to the Supreme Court. The Supreme Court bench, comprising Justices S. Ravindra Bhatt and Arvind Kumar, allowed the appeal and directed TANGEDCO to appoint him as assistant engineer in a suitable department where he could be given appropriate responsibilities. The court also said that the alternate post of junior assistant offered by the corporation to him was inadequate as it was inconsistent with his qualifications. And lastly, the Supreme Court today issued notice and a plea by CBI challenging Karnataka High Court's decision to stay an investigation against Deputy Chief Minister D.K. Sivakumar. The matter relates to a 74 crore disproportionate assets case against him, in which the CBI initiated an investigation in 2019 after receiving sanction from the then B.S. Yediyurappa-led government. This was based on a 2017 income tax raid on Sivakumar's offices and a subsequent probe by ED. In 2020, he was booked by CBI under the Prevention of Corruption Act. This year in June, Karnataka High Court had temporarily stayed the sanction granted by the state government to investigate him. A bench of Justices Aniruddha Bose and Bila M. Trivedi was hearing a special leave petition filed by the CBI against this order. During today's hearing, Additional Solicitor General S.V. Raju told the bench that after the conclusion of almost 90% of the CBI investigation, a stay order was issued by the High Court on the basis of a false statement made in an affidavit. Acceding to Central Agency's request, the bench issued notice seeking the responses of the Deputy Chief Minister and other respondents. But the court categorically refused to stay the High Court order. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.